the president today has proposed a peace plan for Gaza. And I swear I'm not making this up, in which our America First president, I mean, that's his plan, right? America First. His plan for Gaza is to have it run by what he calls a peace board, with who as the chair? Donald Trump.
He's going to run Gaza.
He's going to be in charge of the peace board for Gaza. So, I guess we'll see that happen right after we see the Epstein files. I don't know.
Welcome to a special edition of Legal AF. When we're at a critical moment, whether you call it a hinge moment, a turning point, a tipping point, and you're 10 months into this administration, and the separation of powers doctrine seems to be on life support, or at least severely challenged by this administration. On top of that, you've got a Supreme Court that issues, well, I won't call them opinions, that's giving them too much credit, when they issue orders related to emergency applications in which they take on major pieces of the Constitution. I would have thought if they were going to put the Fourth Amendment out of its misery, they would have had at least the courtesy of doing it in a full-blown opinion, not in a recent decision in Vasquez Perdomo versus Noem, in which they effectively did it, and we had to read Kavanaugh's dissent to figure out what's happening with racial profiling in the Fourth Amendment. So when all that happens, we bring on experts like Professor Peter Shane, a constitutional expert, distinguished scholar in residence at NYU, also on the faculty at Ohio State. And Peter has been with us before. There's two issues I want to cover with Professor Shane, Peter. One of them is going to be on what did we just see happen with the Fourth Amendment and racial profiling? And why is racial profiling okay, but not okay when we're looking at it from an affirmative action or other type of uplift of people who are Black and brown? And how does that tie into separation of powers, which, as Peter has said in his writings, is really a distribution model for power allocation within our government? But ever since the immunity decision, what is the allocation of power and distribution? And do we have checks and balances? Peter, thanks for coming back and briefing our audience on these important issues.
Great to be with you, Michael. And you've asked very big, very important questions. I'm going to take them in reverse order, if that's okay.
Right.
In terms of the big picture, when Trump was campaigning, and certainly when you hear MAGA rhetoric about the federal government, it often speaks in terms of wanting to get rid of the deep state, the bureaucracy. But that's a very incomplete picture of the actual agenda, because the administrative state really has, if I can oversimplify, kind of two big parts. One is the sort of problem-solving, regulatory, help our, health and safety part that protects the environment, protects safe drugs, all of that stuff. And then there's the coercive part, right? The part that polices crime, that enforces the immigration laws, that basically brings the power of the state to bear on individuals. And when it comes to the regulatory part of the big state, yes, this administration is highly focused on deregulation, on really sabotaging the capacity of agencies to do the jobs that Congress has assigned in terms of protecting health, safety, and welfare. But when it comes to the coercive part of the state, they're not downsizing. They're upsizing, right? They want
supersizing.
Yeah, and that's never healthy for you.
Right.
They're giving immigration and customs enforcement more money than the Russian defense budget in order to fulfill what they take to be their mission. And really, I like to think of myself as a pretty moderate and not alarmist kind of person. And as these months have gone by, I find the way I think of things being more and more alarmist, even to me. But what we're seeing is that the Trump administration seems deeply committed to bringing the coercive part of the administrative state to bear on those individuals who I would say are, people of color, regardless of political persuasion, and his political opponents, regardless of race, creed, or color. And it's not even a matter of, ultimately prosecuting people, although, the Comey indictment is a good example of that. But it's what we see in terms of what ICE is doing, and these threats to go after the George Soros supported organizations, and really anyone who dares express a point of view that is different from that of the kind of Trump or MAGA agenda.
Yeah, what we like to say around here is when you have an ICE problem, apply heat. And so we got to apply a lot of heat here. As you said, you're not an alarmist, but one of the things I like about having you on the show is just that simple phrase, what we're seeing is. And I think that's important, because for our audience, it's hard for them sometimes, and for me, and for all of us, to put the puzzle pieces together quick enough about and take the plane up 5,000, 10,000 feet and look down and saying, oh, okay, this, as you simplified it, this is what is happening. And that's important for our audience to understand. Let me stay on the let's stay on the ICE side, on the coercive side there for a minute. We get this decision from Judge Frimpong in Central District of California, Vasquez Perdomo versus Noem, in which she says, of course, to paraphrase the Supreme Court, you don't want racial profiling, stop racial profiling. Mm-hmm. So she says, you know what, I'm not comfortable in if the reason that you have what's called reasonable suspicion, that term of art in the Fourth Amendment world, is that because of what the person looks like, sounds like, where they're located, and what their job is, that those things should not separately or taken together provide reasonable suspicion to then stop, frisk, throw to the ground, detain another human being. Or, as I said to my friends here in Miami who speak Spanish, don't loiter in the parking lot of Home Depot too long deciding in Spanish what you need to go buy for your home, because you've just hit about 4 out of the 5 different characteristics that an ICE officer traveling next to you could then throw you in the back of a van.
Right. So you did, I think, a very nice job, Michael, of summarizing exactly the 4 factors that the explicit policy of ICE was to use as the basis for these euphemistically called interrogation stops. The one thing I think I'm correct in saying, it's not even a matter of what your job is, but what your job appears to be.
Right.
So, and of course, there's a certain correlation here. And we think of, the Home Depot parking lot as kind of seems like the paradigm case where we think day laborers who may lack documentation might show up. But this would be true, for example, even at bus stops. So imagine, I'm at a bus stop in LA, and I'm not, dressed for teaching as I am at the moment, but I'm just wearing a work shirt and jeans as I might on an ordinary day. Maybe I'm carrying a brown bag lunch, and there's a person standing next to me who is also wearing a work shirt and jeans, except their skin is browner, and they either are, and this is the ICE policy, are speaking Spanish or speaking English with what sounds like a Spanish accent. And we're talking about an area in California where 47% of the people identify as being Hispanic of some sort. So
I'm in Miami-Dade County. That's 70% here. Okay.
So under those criteria, that person can be detained. I could not be. Why? It's just what you said. It's just the color of my skin and what I sound like. I mean, the jobs thing, that sort of sounds like it adds to this.
The car wash?
But the car wash, because we know that citizens don't wash their cars, right? Only undocumented people
apparently
wash their cars. So what happened you accurately, again, described what happened in the court below. The Ninth Circuit was asked to stay the order, that is, to stop the lower court from enjoining this practice. And again, let's emphasize, it wouldn't stop all ICE activity. It's just ICE stops based exclusively on those four factors. In the Ninth Circuit, looked at the record, looked at what the district court had done, and they would not stay it. They kept the injunction in place. Then the administration applies to the Supreme Court on this so-called emergency docket, which we've come to call the shadow docket, and they lift the stay. Now, what happens, and again, you alluded to this very correctly, there's no opinion by the justices voting to lift the stay, explaining what they're doing, right? All we get is, in this particular case, we get the dissent from Sotomayor, Kagan, and Jackson. We get a concurrence, actually not a dissent, a concurrence in the bottom line from Justice Kavanaugh. And on one hand, I feel a little bad picking on Kavanaugh because at least he had the decency to say what he was thinking. I
saw what you wrote in your Washington Monthly.
It's what he's thinking is alarming.
Yeah,
and it's alarming in a couple of respects. And one of them is, what you say about seemingly abandoning a reasonable view of how the Fourth Amendment ought to apply here without the full benefit of briefing, without full attention to the actual record. But what's amazing, there are a couple of things that are amazing about the opinion. Another one is how he weighs the competing interests. Before an injunction is granted, and certainly before it's lifted, there's supposed to be a weighing of, the value to the government of not being enjoined or stopped from doing what they're doing, and what's at stake for the individuals affected in keeping those protections in place. And, Justice Kavanaugh says, if you're undocumented, you have at most a minimal interest in not being interrogated. After all, you're here without documentation. Actually says you're here illegally. We don't know that you're here illegally because you could be here applying lawfully for asylum. But he says, minimal interest in avoiding interrogation. And citizens, they have only a slight interest in I'm trying to say this with a straight face, in being interrupted for a brief stop and a short questioning.
So on that, when he wrote that, the world that he lives in, as you called it, the blinkered Supreme Court, we just had, I'm going to play it here, we just had a circumstance where an ICE officer threw a grieving woman to the ground. I think it was even in court. That is what is going on the streets. It's not just, oh, excuse me, sir, would you mind for a moment stopping so I can ask you a couple of questions?
Yes.
Let's show that clip.
No me toques, señora. Adiós, adiós. 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 Oh, come on, man. Come on.
That's what's going on the streets. That clip is showing what's going. Yeah, that guy's going to get disciplined because everybody was filming it. Thank God. And although now, if you're videotaping, that could be an element of being a domestic terrorist and interfering with law enforcement.
If you're following social media, by the way, that kind of interaction is now being referred to by people as Kavanaugh stops.
Oh, there you go. I didn't even know that. Thank you very much.
And with sarcasm emojis.
Yeah, because he gave license and permission.
Right.
To a ICE force, which they said they were going to ramp up as soon as that the decision came out, and they have.
Yes. So, and again, I mentioned this in the essay that I wrote about this. Chief Justice Roberts gets very upset when anybody compares what the court is doing now to the utterly infamous now Korematsu episode. And Korematsu, of course, is the case that technically upheld the conviction of Fred Korematsu, now a presidential Freedom Medal winner, for violating an exclusion order. And the exclusion order basically said you can't be anywhere but basically in the place where you'll be transported to an internment camp. And the opinion says the Supreme Court, the majority that went along with this, said we're being told that to uphold this conviction is to sign off on the internment of Japanese American citizens. We're not doing that. We're just looking at the exclusion order. And Kavanaugh's opinion says, there are allegations that a lot of these things are not, are being done with improper and unnecessary force, but that's not before us. And of course, it's not before them only if they close their eyes.
Right, and that's the blinkered thing.
Right. There's a lot of discretion here. These are not mechanical rulings. Now, we don't know why the other 5 justices in the majority went along with this. They also had, Kavanaugh had an argument about whether there was standing, that is, whether the parties who brought the suit had shown a sufficient risk of imminent injury to be able to bring a challenge to what ICE was doing. And he made a comparison to an utterly, to a precedent that bears virtually no resemblance to this case. Maybe that's what the majority is thinking.
I would think so. You then said, I want to do that comparison here. You then said, well, this is also, well, not this Supreme Court, but a prior Supreme Court who in Parents Involved versus Seattle said, if you want to stop discriminating on the basis of race, then stop discriminating on the basis of race in an affirmative action case. So they have no problem there, right? Don't use black and brown as part of the qualities that you're going to consider for your student body. But yes, use black and brown when you want to stop, frisk, and or violate the Fourth Amendment.
Yes, and I picked on the Parents Involved case because it is an opinion written by Chief Justice Roberts, and it is one of these cases that I found especially troubling. Number one, it completely minimizes the significance of Brown versus Board of Education, but it also repudiates the affirmative action plans at stake in that case were not kind of admissions plans. They were voluntary plans that Seattle, Washington, and Louisville, Kentucky had adopted in order to try to prevent, what we think of as white flight from limiting students' opportunities for an actually racially integrated public education. And basically all these plans called for is if students within the district who wanted to transfer from one school to another were transferring in a situation that would have made the school that they wanted to go to kind of racially identifiable in the sense that, it would be yet more grossly disproportionate of one race as opposed to another compared to the district as a whole, then they couldn't transfer. They would have to go to the school that they were first assigned to. Nobody was being denied an education. Nobody was, and it wouldn't even come into play except in very limited circumstances. But this attitude we've seen, in K-12 education. We've seen it, of course, in higher education in the Students for Fair Admissions versus Harvard case. The court seems, I'll just say, to be deeply concerned about the prospect of what might be experienced as racial discrimination by white folks. They seem not to be as concerned about racial discrimination as perceived by people being thrown to the ground.
And I might be misremembering this, Peter, but didn't Kavanaugh also just casually suggest that if these people are thrown to the ground, don't worry, there's excessive use of force and other types of Fourth Amendment or 1985 cases, but that's not true. I don't think those cases would be allowed today. Those types of cases.
Yeah, honestly, I don't know enough about the status of constitutional torts cases. They might be subject to qualified immunity.
Right.
There might be other ways to get around damages.
So easy just to say, just let them bring suit. The people I just said don't have standing. Let them bring suit. Let's do that.
Right.
Let's switch gears and end the hot take on the separation of powers. I went to law school a long time ago and learned a lot about separation of powers and that distribution of power that you talked about. Learned a lot about, I hope it's Brandeis talking about the grinding of the, am I got it right? Brandeis, right?
Right. He said it's not for this. It was not adopted to promote efficiency, but to help guarantee liberty.
Right. We want the grinding of the three plates of the three co-equal branches of government. We don't want flywheels just kind of greased. And then we get the immunity decision, which for me, and I might be overstating it, and you're the constitutional scholar in this conversation, but I said it created a presidential leviathan that now levitates above the two other branches, and we no longer have the delicate co-equal balance that we once had.
Yes. So I think, we may have covered some of this before in our prior conversation, Michael, but the way the Roberts Court describes the allocation of power in the Constitution rests on three premises that I think are wrong. One is that the president is, and I'm not making this up, this is a quote, a one-person branch of government. The fact that Article 2 of the Constitution refers not just to the president, but also to executive departments, we never get to that clause. It's all executive power is vested in a president. So
why do we call it an administration then? Why don't we just call it Trump?
Yeah, right. The second premise is that what makes the government legitimate, and this would be shocking by the way, for all the originalists out there,
yeah,
it's amazing that the court considers this historically based. They actually say, and the framers would be very upset by this idea, that what legitimates government is that everyone who works in the executive branch from top to bottom in what they call a clear and effective chain of command effectively reports to the president. And the third proposition is that when it comes to supervising this vast establishment, at least, or I should say, especially with regard to criminal prosecution and investigation, the court says the president's powers are conclusive and preclusive. Congress can't regulate them, and courts can't review them. And this is just a view of the presidency completely alien to the founding generation. I do think, there's an interesting, important debate to be had on the ways in which we want a presidency sufficiently empowered to help, government to solve problems, to produce solutions that are consistent with the collective needs and demands of the people. We don't want a powerless presidency, but there's some distance between a presidency under law and, a presidency which is, one person saying what I say goes. And I just want to say, just have to add here, every day shows an administration working at odds with its most explicit promises to its own base. I don't know if you've seen this, but the president today has proposed a peace plan for Gaza. I swear I'm not making this up, in which our America First president, that's his plan, right? America First. His plan for Gaza is to have it run by what he calls a peace board, with who as the chair? Donald Trump.
He's going to run Gaza.
He's going to be in charge of the peace board for Gaza. So, I guess we'll see that happen right after we see the Epstein files. I don't know.
Well, maybe he'll announce that to the 800 military brass who are leaving their posts and their stations and all coming to be in one room with the president at Quantico. Nothing. What could go wrong with that plan?
Right.
Tomorrow, nothing at all. Peter, let me end it this way. Congress, which used to do its job, sets up agencies, boards, and commissions in the old days, wanting them to be nonpartisan or bipartisan, does that through various ways, staggered terms and limits on how many of one party can be on. Okay, so those days are all over, or as I joke, they've been slaughtered in the Rebecca Slaughter case of the FTC. And now you have the Supreme Court saying, as soon as you see the issue presented or the question, please brief the following issue. Should Humphrey's executor be taken out in the back and shot once and for all so we can stop nibbling away at it and just get rid of it? Yes, we know the answer. So if you're Congress, a future Congress, first of all, don't you want your agencies and commissions and regulatory bodies back? Because wasn't one of the foundations of doing it is that they were bipartisan to help the American people? That's one. So blue pencil should not be allowed. Mm-hmm. Secondly, why would you ever create a new agency, board, or commission if you're Congress under the Supreme Court's rulings?
I don't think this court would be disappointed if Congress decided not to create new administrative agencies, or indeed to further empower the ones that already exist. The thing about these agencies, they represent an attempt, and again, not a perfect attempt. These agencies aren't perfect any more than the other executive department agencies are perfect. But they are trying to achieve something that is, I think, at the same time, the most important and least sexy quality of good government, which is balance, right? These are not agencies over which presidents have no influence. The president appoints
the chair.
He designates who is the chair. Yeah. He's going to, within the course of an administration, probably appoint at least a majority of the commission. But what does it mean to have a commission that is independent in the sense that the president can't fire people at will? Well, at least the minority party has a voice, right? The minority party gets to do something to help keep the majority honest. Maybe it'll trigger congressional oversight. Maybe it will trigger judicial review. Maybe it will get the press involved in a way that you're not going to get when you don't have multiple voices. You have people, even within the same party, expressing independent opinions within the permissible range of discretion that they have. Trump, rails against, Jerome Powell as chair of the Board of Governors of the Federal Reserve. Powell's a Republican, right? Powell was a Trump appointee.
What idiot appointed him? You.
Yeah, right. And, a government in which, even within the governing party, there is no room for people to express different points of view within the scope of their legal discretion is a very, very dangerous government.
Does this mean, Peter, since Congress is no Congress in its right mind now would create a new executive agency commission or a board, does that mean the president now has the power to create his own agencies, boards, and committees? Well, what stops Trump from creating his own shadow SEC or NLRB? Like, what stops it?
Okay, this would be worthy of another hour's discussion. But let me just
say, you're going to come back.
Let me just say, the power to create offices it belongs in Congress. Again, it's not an executive power. The framers expressly rejected this idea.
Right.
But Trump is trying effectively to do what could only be done in earlier generations with congressional authority, and that is, deprive certain agencies of their functions, consolidate functions within different agencies. He's trying to do this by shuffling the money around, by firing personnel, and the court, which seems absolutely desperate not to put itself in the position of saying no to Trump, lest Trump say, we're not doing that. They are letting him get away with it until they just can't put off the issue anymore. Now that what's interesting, you may have seen that the Trump administration followed through on a promise that the Solicitor General made in an earlier round of the birthright citizenship litigation. And they have asked the Supreme Court, not in an emergency application, but in the real way things are done, to review the question of birthright citizenship. And I think this, and maybe the tariffs case also, will be cases where the court simply cannot, if it has any sense of responsibility or fidelity to its own ideas of originalism. They're just going to have to step up and take the risk of telling Trump what the law is, even if it's not going to make the president happy.
Absolutely. And John Roberts, I don't want to hear his complaining about birthright citizenship in the 14th Amendment, that it can't be by a stroke of a pen eliminated by an executive order. And if they rule something different, or that tariffs belong over on the Congress side of the ledger, not on the president's side. Now, by the way, on tariffs, and we'll do a whole nother show about it, he's got all the other powers that he can use, and he's already started it. I don't know, Section 232. He's got all sorts of things he can do through the Commerce Department, and are the equivalent of it. But he just can't do exactly what he did through IEPA. And
he can't do it whimsically.
So that's great. So those are the two cases. When those come out, or before, you'll come back and talk to us and brief our audience, Peter?
When you want to talk, Michael, I'm always around.
All right, that's fantastic. Thank you for Professor Peter Shane coming back to Legal AF. Such a big hit the last time. You and I both woke up and were like, a couple of 100,000 views for Professor Peter Shane. Our audience is in. They are totally. They are in, and they couldn't wait to have you back here. Thank you so much for taking time out of your busy. You're teaching this semester?
I am. I'm teaching legislation in the regulatory state.
Oh, dude, I love when I have you've become our scholar in residence. Thank you for being on Legal AF, and we'll see you next time.
Thanks so much.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.